Iowa home sellers, you accepted an offer. The sign says, sale pending. You've mentally started packing, and it feels like the hardest part is over. But here's the truth. There are 5 quiet things that can still blow up your sale between now and closing day. And the biggest one, it's usually hiding in a document most sellers have never even read. Stick with me, because I'm saving that one for last. I'm Jeremy Danilson, a real estate attorney here in Iowa, and my team has supported over 10,000 real estate transactions in the last few years. So I've watched all 5 of these trip people up, usually when they thought they were home free. Here's why this matters. Once you're under contract, a lot of sellers go quiet and just wait for closing. But that gap between accepted offer and keys handed over is exactly where deals fall apart. Give me a few minutes and you'll know all 5 danger spots and the one simple move that diffuses each one. Let's get into it. Number 5, the disclosure slip. In Iowa, you're required to fill out a seller disclosure statement. Basically a written list of what you know is wrong with the house. The leaky basement, the roof you patched, the furnace that's on its last legs. Here's where sellers get hurt. They mention something out loud to the buyer, but they leave it off the written form. But in real estate, if it's not in writing, it's a he said, she said waiting to happen. So the buyer finds the problem after closing. And now you've got a phone call from their lawyer. What to do instead? Put everything you actually know in writing, on the form. Honest and boring beats clever and sued every single time. Number 4, the buyer's loan falls apart. Most buyers come in pre-approved, and sellers hear that word and relax. But pre-approved is not the same as done. The buyer changes jobs, opens a new credit card, or the lender rechecks their file a week before closing, and the loan evaporates. So you're back to square one, except now you've lost a month of market time. What to do instead? Lean on your closing team to confirm the buyer's lender is actually moving, that the appraisal is ordered, and underwriting is rolling. You can't control the buyer's bank, but you can make sure nobody's asleep at the wheel. Number 3, the inspection standoff. The buyer's inspector is going to find things. They always do. That's normal. But the danger is not the report. It's how the repair requests get handled. The buyer asks for a giant list. You dig in. Both sides get emotional. And a sale that should have closed dies over a $1,000 disagreement. So the deal cracks not because of the house, but because of the back and forth. What to do instead? Go in expecting a repair conversation. Decide ahead of time what you'll budge on and keep it about dollars, not pride. A cool head here saves more closings than anything else on this list. Quick pause. If you're selling in Iowa and you'd rather just have somebody watching all of this for you, making sure the disclosures are clean, the buyer's financing is real, and nothing slips, that's exactly what my team does. There's a link below to talk with us. No pressure, just a conversation. Okay, the last 2, including the big one. Number 2, the appraisal comes in low. The buyer's lender sends out an appraiser to confirm the house is worth what the buyer agreed to pay. But if that appraisal comes in under your sales price, the bank will only lend on the lower number. So now there's a gap, and somebody has to cover it, or the deal stalls. What to do instead? Don't panic, and don't assume the sale is dead. Usually have options. The buyer can bring extra cash. You can meet in the middle, or you can challenge the appraisal with better comparable sales. Knowing those options before it happens is what keeps a low number from becoming a dead deal. And number 1, the one I told you was hiding in a document you've probably never read. It's a title problem buried in your abstract. Now, your abstract of title is basically your home's medical history. It's a thick stack of paper showing everything that's happened to your property, every owner, every loan, every lien. And a lien? Think of a lien as a sticky note the world attaches to your house that says, you owe me first, an old unpaid contractor, a tax bill, a mortgage that was paid off but never officially cleared. Here's how it actually works. Your abstract gets updated, and then it goes to the buyer's attorney or the lender's attorney to read through and write what's called a title opinion. Think of that title opinion like a mechanic's inspection report before someone buys a used car. They go through the whole history and flag anything that needs fixing. Those flags are called title objections. Here's the gut punch. Most sellers wait, so that review doesn't happen until a day or two before closing. So when an objection pops up, there's no time left to fix it, and the closing gets shoved back by weeks. And look, I'll be honest, we lawyers didn't exactly make this stuff easy to follow. Here's what to do instead. The week you accept the offer, get your abstract updated and sent over so the buyer's attorney can start their review early. The sooner they have it, the more runway everyone has to clear any objections before the morning you're supposed to hand over the keys, instead of scrambling on closing day. So let's lock it in. After you accept an offer in Iowa, the 5 things that can still kill your sale: a disclosure you didn't put in writing, the buyer's financing falling through, an inspection standoff, a low appraisal, and a hidden title problem in your abstract. Every one of them is survivable if you see it coming. If you want a team that watches all 5 for you, from accepted offer to closing day, click the link below and talk with us. That's what we do all day, every day. And if you're wondering what closing day itself actually looks like, who's in the room, what you sign, when you get paid, I walk through the whole thing right here. Go watch that one next.